using those words in their lyrics?
I don't know specifically those lyrics, no.
Okay. You ever hear of Rocco?
I have.
Okay. Were you aware of his song, You Gangster Right?
I don't know that song.
Thugger Daily just dropped a bomb. What does Thugger Daily say? Lots of responses from the state and some from the defense will be coming in today. First up, the state responded to Steele's motion to revisit the rules of evidence and for correct rulings on objections in 4 separate responses. So we got a lot to get to. So let's go ahead and get into this first one without delay. And again, all these came from Thugger Daily. Y'all go check Thugger Daily out over on X. This is Young Thug, aka Jeffrey Williams, aka represented by Brian Steele, versus the state of Georgia. This is a letter to Judge Whitaker. Here we go. And this is the state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. Here's the intro. On June 10th, 2024, Young Thug moved this court to vacate proper rulings on state objections precluding cross-examination questions which assume facts not in evidence. Okay, let's read this note so we can get a little bit of background. On July 10th, 2024, Young Thug filed an amended motion. Young Thug's motion addresses multiple separate evidentiary rulings. The motion addresses paragraphs 10 regarding state's objections to assuming facts not in evidence. All right, defendant Young Thug does not include a request for specific relief or provide authority to substantiate his request. Instead, Young Thug critically asserts somehow his right to effective cross-examination has been curtailed. Dang. Trial court correctly sustained state's objection to question assuming facts not in evidence. Young Thug's motion should be denied. Okay, argument and citation of authority. We're actually going to get some cases here, so this will be good. At the outset, Williams never provides authority that inquiring into unproven and irrelevant areas, to wit, facts not in evidence, classifies as specific mode of cross-examination imparted by constitutional requirement. Okay, and we're going to see Johnson versus State. Even grounds that are constitutionally protected, however, may be subject to judicial controls. The right to acquire into partiality and bias, however, is not without limits. The Fifth Circuit has made it clear that questions which assume facts not in evidence are constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. Okay, that makes sense here. And then they say the rule permits court to precluding questions that obscure truth because there are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. Well, if we look at how this trial's been going, I'm sorry, y'all, but you're not getting the benefit of the doubt, prosecution. I can see what you're saying. I'm not sure specifically what Brian Steele was trying to get changed here. Hopefully they'll give us a little bit more background, but we have no faith in you guys. I'm sorry. Young Thug's motion attempts to constitutionalize areas of cross-examination that is not so protected, even assuming arguendo. Is that Spanish? That questions assuming, I don't know what that means. That questions assuming facts not in evidence were of the same stripe as an area like bias. Rules 401 and 403 and 611 would preclude Young Thug's proposed inquiries. All right. Williams' Sixth Amendment rights to effect cross-examination was not infringed by disallowing questions seeking to elicit facts not in evidence. Pursuant to both 24-1-103 and 24-6-611, the trial court has correctly prohibited Young Thug from posing questions that assume facts not in evidence. That's an interesting statement there. Well, we'll keep it moving. We've got 24-1-103 holds that the jury proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Courts are mandated by 24/611 to exercise reasonable control over the mode and ordering of interrogating witnesses and presenting of evidence. Except for when it comes to Lil Woody. 'Cause we're just throwing all that out the window. But anyway, in order to make the interrogation and presentation of effective for the ascertainment of the truth, make the interrogation and presentation effective for the ascertainment of the truth. Reading these statements in conjunction with one another, courts are authorized to present counsel from asking questions in the hearing of the jury that are premised on inadmissible evidence to facilitate assertment of the truth. Young Thug asserts that the court's sustainment of objections for questions that assume facts not in evidence curtails his Sixth Amendment constitutional right, but cites no legal authority for that proposition. We kind of heard this in Weinstein's last opposition that he filed, basically saying that Brian Steele didn't cite any legal issues when it comes to, when it comes to this evidence. Case law explains that the Sixth Amendment provides two types of protection. Okay, we're going to skip through that. He also had objections to assuming facts not in evidence are proper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considering information that is never properly admitted as evidence in trial. Okay, you can see United States versus Almanzar. The court overturned a trial judge's decision to set aside a jury verdict based on insufficiency of the evidence because of the district court. And they assumed facts not in evidence and made unsupported assumptions. Young Thug's improper questions, which assume facts not in evidence, could confuse the jury deliberating, similar to the trial judge in Almanzar. Yeah, I wish they would point to exactly where this happened, because they're just saying, oh, he did it. And I would like to know where he said it, but I guess that doesn't have to be included here. Young Thug classifies such objections as specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. Moreover, Young Thug seeks to ask questions that imply matters at best Young Thug cannot substantiate. For example, okay, here we go. Young Thug asks Deputy Belknap, do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? Okay, so she's saying, I guess they're saying that that's not necessarily true. And we'll go to 11. Watch live. Young Thug YSL RICO trial, Georgia versus YouTube. Okay, and they actually referenced the video. Let's see if we can find this. This is super helpful. They're actually doing their job in this one. So we're going to go to the 6:12 mark. Let's see what Brian Steele was talking about. Here we go.
All right. Were you aware, and I'm focused on the SMM or SMM or sex, money, murder, any of those words, and Pistol Pete or Two Guns Up, Pistol Pete, okay?
Yes.
Were you aware that prior to 2012, and I'll just say April 2012, there were other artists, musical artists, who used sex, money, murder, SMM, SMM in their lyrics?
Yes.
Were you aware before April 2012 that there were other artists, known artists, who used Two Guns Up, Pistol Pete, Two Guns, something that, using those words in their lyrics?
I don't know specifically those lyrics, no.
Okay. You ever hear of Rocco?
I have.
Okay. Were you aware of his song You Gangster Right?
I don't know that song.
Lyrics, oh, you don't know the song at all?
No, sir.
All right. You aware of Nas and AS?
I'm sorry?
Nas, N-A-S.
Yes.
2002, Brooklyn, New York,
Nas.
the song Get Down.
I know of it, yes.
Okay, music.
All right, so basically he's got him on the stand going back and forth, and then we're going to fast forward to the point to where the state has an issue with. Here we go.
Do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case is rap lyrics?
Objection to speculation.
I stay in the question. Do you realize that?
Objection.
Stay in the question, Mr. Steele. Come on, Mr. Steele, let's move on. Do you have...
Brian still said, come on, man. Let me have this one, Judge. So yeah, they wouldn't let him have that. That's the point where they're talking about. Okay, so let's keep moving through that. I mean, I can see what they're saying there. To begin with, this question is predicated on a falsehood as this court's detailed order on the introduction of gang lyrics proves this is not a true threat case. And not one defendant is being prosecuted for expressive activity of any kind. Okay, and they go to Exhibit A, which is 12. Chief Judge Glanville order granting admission of evidence of lyrics at trial, November 27, 2023. And this is, a lot of people had a big issue with the lyrics being used. And we've had this conversation and talked about it before, especially when this whole RICO case went down, because there's so many people, as y'all are even talking about in the chat, that have gotten in trouble for lyrics and some of the things that they said in their lyrics. And there's people who have even been caught up and gotten arrested and are in jail because of things that they said in their music. So yeah, they're being used and they're putting them in there. And thank y'all for the super chats. I'll be reading those here in a second. So Chief Judge Glanville, all right, he ordered it, found no defendant in the in-state case is being prosecuted for a charge involving a true threat or any exercise of any right protected by the First Amendment. Furthermore, the court finds that in neither briefing nor argument did any defendant demonstrate to the contrary. The emphasis was added intentionally. It should be noted that no defendant or group on their belief filed any motions challenging the legal analysis in this court's order on the admissibility of gang lyrics. Is that true? How did they not challenge it? It should be noted that no defendant or group on their behalf filed any motions challenging the legal analysis in this court's order on the admissibility of gang lyric evidence, much less sought a certificate of immediate review related to the same. I really find that surprising. Maybe it's just not that big of an issue, and it's something that they could easily deal with at court. But if that's the case, why wouldn't they try and, I don't know. We'll have to look into that a little bit more. Plus, the line questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants' lyrics in criminal trials. The question also assumes that only rap lyrics have been prosecuted and thus is permitted on evidence never admitted at trial, a point that was refuted in the state's briefing and hearing on the admissibility of gang lyrics and evidence. Okay, so they're basically going to go back and forth through this. We'll get to the conclusion and then we'll move to the next one. Young Thug's assertion that his Sixth Amendment right have been curtailed by the court's sustainment of the state's objections to question that assume facts not in evidence is invalid and unsustainable. There's no constitutional or statutory right to ask irrelevant and supported questions during cross-examination. The prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitutions and rules of evidence. Young Thug's motion should therefore be denied. Respectfully, Adrian Love. All right. So what do y'all think, man? There's still a lot of background we have to give, but we got to see it in real time. What actually happened, a little bit of the line of questioning from Brian Steele in this instance. I can kind of see what she's saying, but I think there may be more to it, and we'll have to see what Judge Whitaker says on this.